Hello everyone, my name is Natalia Gavlin and I am an immigration attorney in New York City. Today I would like to tell you about the immigration court. Now, this will be a video for people who have immigration court hearings scheduled because they have applied for asylum. I will later record and I will put them up on YouTube, videos for people who are applying for different forms of relief. So this is strictly when you applied for asylum, the immigration officer did not approve your case, he or she referred it to the immigration judge, and now you have a hearing scheduled. Now, what to expect? The first hearing is called the master hearing. You will get a hearing notice. It will inform you of the day and the time and the place to appear, and it will set out all kinds of responsibilities that are required of you, like what you need to do and on the day of the hearing. So, although it's called a master hearing, it's more of a conference, and you will not be required to present your case on that day. Some people think they have to do it on that exact day. That's not so. You have to show up though. You do have to appear. And there are very serious consequences for those people who fail to appear for their immigration hearing. So when you come to court, you will see that the room is full of people. Master hearings are scheduled on the judge's calendar, and there are approximately 50, 60, sometimes 80 hearings on exactly the same day before the same judge. So you will see a room full of people. It's going to look like chaos, but you will also see there will be a prosecutor. We call them trial attorneys, TAs. And then there will be an empty desk where you and your attorney will have to sit. As I said, you do not really need to respond to any questions, possibly the name, maybe an address confirmation if you speak English. Other than that, most judges do not really question respondents, and respondents is the official term that we use to refer to people who are before immigration court. So once your attorney responds to the allegations and the charges on the notice to appear, the judge will offer you an individual hearing date. That is the final hearing date. That is the date when you will have to come back and you will have to present your case. Just like you did before the immigration officer, you will have to do this in the context of immigration court. Now, what to expect on that day? First of all, between the master to the individual, you should have been working on your case. Depending on the timeline, sometimes, if the hearing is 3-4 years into the future, then obviously there is not much that you need to do right away. But still, you have to keep in mind that you have a certain strategy, you have a certain claim, and you have to work on collecting evidence to prove your case. What is the evidence? You have already submitted a big packet of documents at the asylum office, so you're thinking, what else do I need? My case is already ready. It's not, because as the time goes on, the situation changes, especially the situation in your country. You have to keep an eye on that, because if the situation changed one way or the other, it might affect your case. If the situation got better, the government attorney might argue that you no longer have the fear of returning. If the situation got worse, then you have to argue that that actually helps you, because now you even have more reasons of fearing the return. So you have to collect the evidence. In addition to that, in immigration court, you can present witnesses. And you can present anybody. These could be expert witnesses, although I will be honest with you, I don't use expert witnesses in my cases most of the time. I really don't, because you can find good background information through different sources. Amnesty International, Human Rights Watch, obviously Department of State publishes a country conditions report, and so many other sources will provide you with such comprehensive information about the country that I really do not use country conditions experts. But other witnesses, of course, are always welcome in my cases. Who are the witnesses? The witnesses can be anybody, preferably with a legal status in this country, green card holder or a citizen, or even someone on a visa, no problem, who can come and talk about what they know happened to you. So this could involve someone who can confirm certain things happened to you in your home country, or maybe if you only met them in this country, maybe they had similar experience. Maybe they are also from your country, so they can say that these sorts of things happen. Again, you have to be very careful. You're not presenting them as an expert about the conditions in your home country. You're just saying, look, this happened to me, and this happened to my witness. So it kind of shows, it corroborates the fact that certain things happen. So all of this has to be submitted to the court. Most judges have, they call it call updates. These are the guidelines by which the documents have to be submitted to court. Most of the time, it's about 30 days before the final hearing. There are some judges who will move it out to 90 days before the final hearing. Few judges who have been doing that in New York City have since retired, but you still have to be careful what the rules are, because if the judge says you have to give me all the documents and all the witness lists 90 days before the hearing, and you bring it on the day of the hearing, guess what? They will not accept it, which means you have not properly corroborated your case. It will be used against you. So be careful about the timing. But let's say you submitted wonderful packets of documents, country conditions, affidavits from family, friends, additional medical records, maybe letters from someone in the United States. You have painted a beautiful picture. Now what? You still have to come and testify. Now, when it comes to testimony, again, just like the preparation for interview, preparation for your individual hearing is key. Nothing beats being prepared. And when you had your asylum interview, hopefully someone in the room, in the form of your attorney, was taking good notes so that when the case is now presented to the judge, you have an idea of what was said and what was asked of you. Because time passes. Sometimes the difference between the asylum interview and the final individual hearing date could be 3-4 years. You will not remember what you said there. That's why it's so important to have an attorney with you at the asylum interview so that the notes and the record is preserved. And then when you're preparing for your individual hearing, you can go over that. You can see what was asked of you so that when the same questions come up in court, you can respond in a consistent way. Or even if you want to change your answer, let's say you made a mistake there, you will at least anticipate that they will bring it up and say, we asked you this. You said one thing, why are you saying something else? You want to be prepared. So immigration in court individual hearing, what to expect on the day of the hearing. You can expect to find a judge in the courtroom. You can expect to find the government attorney, the trial attorney as we call them. And you can expect to find an interpreter. The interpreter is provided by the court. It will be the interpreter who speaks your language. They are not on the court side. They're not on the government side. They're not on your side. They're there. They're independent. And they're there to do the best possible translation. Now, what I have to say about interpreters is they're doing a good job most of the time. But what I tell my clients is things happen. So if you're at your hearing and you notice that the interpreter is making a mistake, do not ever be shy. Do not ever be afraid to bring that up. You have to let the court know that the interpreter is not understanding you or you're not understanding them, because if it's the interpretation issue and only the two of you know this, we will not know that. The judge will not know that. And they will use the things that are improperly translated against you. So it's very important, if you ever feel that the interpreter is not fully explaining what you're saying, it's not a word-for-word translation, it's not accurate or whatever, make sure you let everybody know right away. Say, I'm sorry, that's not what I said. There's an issue with interpretation. Maybe I need a new one. So the way the the individual hearing goes forward is usually it starts off by marking the evidence. And that means that everything that has been submitted in the past, your asylum application, notice to appear, all the supporting documents submitted at the interview, all the supporting documents you've been submitting to immigration court, witness list, etc., everything gets marked into evidence as exhibits. And once that happens, then the judge will ask you to take an oath to tell the truth. Most of the time, they will ask you to sign your application, once again, just like you did at the interview, and then the questioning starts. Now, there are two parts to the questioning in immigration court. And the first part is direct examination. Direct examination is where your attorney asks you questions. Now, what kind of questions will your attorney ask you? The attorney will ask you questions about your case, because it's my job to bring out every single detail about your case to paint a pretty nice picture for the judge. So the way I explain it to my clients is that when you come to court, you have a blank page. There is no testimony yet. Yes, you have a beautifully documented case on paper. Exhibits have been marked, but you haven't testified yet. So it is my job as your attorney to bring out the necessary details to show to the court that you fit within the definition of asylee. So I will ask you questions that I think are necessary to bring out all the past harm, all the future fears, everything that has to do with your asylum case. Now, what you want is for the judge and for the trial attorney to believe you. You want them to find you credible. Credibility is enormous in immigration court. So you want them to believe you. How do you do that? You do that by being genuine. You do that by giving them detailed description of what happened to you. Consistent description. It has to be consistent with what you said before. It has to be consistent with what's on your documents. It also has to be consistent with what your witnesses will testify. So it's a coordinated effort between you, your witnesses, and your attorney to make sure that there are no holes in this story, that nothing is inconsistent. It's all just beautifully perfect and very detailed. So once you start testifying, you're painting a picture for the court. And the more things you say, the more vivid, the more convincing the picture becomes. You want the judge to look at you and believe that what you're saying really happened. So, I mean, different people have different way of expressing themselves. Some people are not as comfortable, and I understand under stressful environment where you're in court testifying about asylum of all things. Of course, it's very stressful. It's very difficult to be narrated, or it's difficult to be very expressive, but you have to try. I'm not saying step outside your comfort zone. This is not acting class. We're not acting, but you have to be convincing. Do whatever you can, because this is your chance. If you can paint a nice picture, then the judge will believe you and he will grant the case, or she will grant your case. So what kind of questions will I ask specifically? We're limited. As a respondent's attorney, I cannot ask leading questions. I can only ask questions like what, when, how, who, where, open-ended questions. I cannot give you information and then just ask for a yes or no, because that would be leading and I will get objected to. And I don't want to be objected in court. I don't want to give that power to the trial attorney where they interrupt me or they stop me or they make me look like I'm doing something wrong. So yes, I will stick to the rules and I will only ask you open-ended questions, and I will give you the stage so you can then answer and give full details. During that time, the immigration judge, some immigration judges will step in, so to say, and they will start asking their own questions. Let's say you're talking about something and I want to move to the next question, but the immigration judge goes, I have more questions, and they will start asking you to get more details. Don't be afraid of that. Nothing is wrong with your case. This just shows that the judge is interested to hear more information. Look at it as a good sign, as an opportunity to give them more details, because apparently you have been painting this nice picture and they're loving it and they just want to see more colors. So don't look at it as a bad thing. Oh my God, the judge asked me questions. What is that? That's fine. That's fine. So don't be afraid. So after direct examination, now the trial attorney asks questions. That's called cross-examination. And you will notice that it's a totally different tone of voice. Again, human factor is involved. Some trial attorneys are adversarial. Some of them are aggressive. Some of them are sweet. Some of them are nice. Some of them are respectful. Some of them are disrespectful. You do not know who you're going to get on that day. But it really doesn't matter. All my clients want to know, who's my trial attorney? Can you find out who it is? I said, I can find out, of course. But I really do not even care to find out, because yes, it's important to know who your adversary is. And it's important to know how to prepare. But at the same time, if we are ready, and you have heard every single possible question that I could have asked you, you're prepared. It doesn't really matter what mood they're in. You will do just fine. And I also teach my clients, and I also talk to them a lot about how to handle stress and how to handle stressful situations. Because a lot of the time, the way the trial attorneys come off is they will force you into saying things that you might not even agree with. So they will build it up from far away, you don't even notice it, and then you hear that question and you're tempted to agree because you think, well, it's coming from the government, and the way they're putting it forward is like, I kind of have to go like this and say yes. You don't. You do not need to do that. You have to listen to the question, you have to understand the question, and you have to answer it. It doesn't matter how much they're pushing you for it. It's very important to stand your ground. And I tell my clients it's a two-people game, it's a two-people situation. I come in confident as an attorney because I took your case. I believe in your case. So I am confident and I'm prepared. You have to be on the same level. You cannot be so much below me on a level of confidence. You cannot come in and shake. You cannot come in and not believe into your own story. We have to be a team. We come in, we're confident, like I said with the green card. We're here to get asylum. And it doesn't matter how long the questioning takes. It doesn't matter if the cross-examination goes on for 3 minutes or 49 minutes or 3 hours. At the end of the day, we're confident and we're a team because we're here to do our job. So that is very important. I mean, most of the time when I finish an asylum case in court, and I have to step aside and say that I absolutely love court. Anything litigation related, I love it. I know people do not have the same idea because they think, well, it's stressful, it's terrible. What do you mean? I love it because it's you get there and you fight to the end for your client and you put up the best possible presentation and then you win. And there's nothing more rewarding than getting a grant at the end of a hearing, especially on a very tough case. I mean, this is exhilarating. So that literally fuels me. That is the reason I keep doing these things. And I don't see I will ever stop because it literally gives me so much energy and it gives me so much drive. I don't know if it's visible because I got a little bit more animated just talking about it, but that is really my feeling about immigration court. So let me just step back to what I was saying. You have a cross-examination conducted by a trial attorney. Again, the judge might ask additional questions, not to be worried about that. And then at the end of the trial, when there are no more questions asked, the judge will issue a decision. Now, there are a few ways how this can go. The judge can issue a decision right on the spot. Before the judge issues a decision, the judge will ask the government attorney whether or not they have an opinion about this case. Now, if the trial attorney says, Your Honor, I defer to you, meaning, Your Honor, you decide. I have no objections, whatever you say will stand. That's beautiful. Because if the judge wants to grant you at that particular point, they will. And it will be a short decision, it will be just a piece of paper, and they will just sign it and say, asylum granted. That is beautiful. Sometimes the trial attorney will have their issues with the case. They will argue to the judge, I don't believe this person, the credibility, this, that, we don't have corroboration, whatever the situation might be. Now, at that point, the judge can still grant your case. The only difference is the judge has to issue an oral or a written decision detailing every single reason why they're either granting your case or they're denying your case. And the reason that's so is because one of the sides is disputing, so he or she has to put on a paper, has to make it obvious of what their reasons are for granting it. And if the government attorney chooses to appeal, in 30 days they might, but very often they reserve and they still don't appeal. But point is, those are the two ways the decision could go. There's a third option, and again, depending on scheduling, sometimes the judge will have no time on that day to issue a decision. So they will simply ask you to come back at the earliest possible date, so then they can then issue a decision. So it's not to worry. The point is you will get your decision eventually. It's just about the timing of the court and the way the trial attorney handles the case. So sometimes I hear a question, what if the immigration judge orders me removed? Does that mean they're going to deport me? No, they're not going to deport you. According to the law, you have 30 days to appeal the case. For those 30 days, the judge's decision is not final. And I will do a separate video on the appeals to the Board of Immigration Appeals and also to the Circuit Court. But I will just tell you that you do not need to worry that immigration police will show up in court and take you out as soon as the judge orders you removed. It doesn't work that way. You go home just the same way. You're given 30 days to file a paper, to appeal, and you can proceed, to dispute your case and argue your case to other courts. So don't worry about that. I think I covered most of the issues when it comes to immigration court. Obviously, I could talk about this for so much longer. As I said, I love this practice. I think it's fascinating and it's very rewarding. And if you have any other questions, you can contact me. Thank you.